Today, I'm going back into the personal status correction, what we call the master file, and I'm going to just go over the flow of it one more time very briefly, and I'm going to point out some subtle updates. And this is just a video to make sure that everybody's still on course, that you understand what's going on in there. So let me log in real quick. And again, if you're doing personal status correction, I highly encourage you to access this information via a computer instead of a smartphone or a smart device, because you really can't study the templates the right way. Some PDFs may not download on your smart device, and there's a lot of PDFs embedded in the site. So again, if you're actually doing some work, I encourage you to visit the site from a computer instead of just a smart device. Now, so today, see if I can scroll. It's kind of hard. Let me see here. Let me do this like this. Sorry, let me adjust this to make it. Here we go. I think this is better. All right, now we're going under the advanced topics, personal status correction. And so again, just to briefly go over this, you see these different steps here: 1, 2, 3, 4, 5, 6, and 7. And everything doesn't have to be done in this order, but as you go through it, you'll see why I put things in this order. You'll see how they flow and connect together. But you may find when you're doing your documents or based on your research, there's a requirement that you do one thing before another. That's fine. There's not just one way to do things. We're just trying to lawfully navigate. So to follow along, you watch these videos in order. That's why I put them in order: 1, 2, 3, 4. And right here, this video that I'm making right now is going to be video 5. And it's going to further, so it's going to go into the flow of everything we talked about. And I'm telling you, since I made this first video, it might have been a year ago, I don't know. So I didn't just literally go back and watch what I put here, but I'm pretty sure the flow will be the same. So understand, sometimes things may change in the more current and recent information. Don't be confused about it. It's just kind of common sense. As we learn more, we adjust things and we do better. So we started out talking about the master file, then we went into the revocable trust. That's the first thing that I really start focusing on, is the revocable trust. And the reason why I focus on the revocable trust first is because, well, first off, a revocable trust is a type of trust that the grantor can change his mind about things. He can alter the trust, he can amend the trust, he can revoke the trust, as opposed to an irrevocable trust that's pretty much set in stone. So as you're figuring out these things, how to manage, control your estate when you become competent, I like the revocable trust because it gives you the ultimate authority, and you can still operate in trust because a trust is necessary to administer and control estate. So we start with the revocable trust because also you can hold title to assets, documents, and things in trust. So for those who happen to be Moorish Americans that have done different levels of personal status correction, you may find the reason to take certain documents, certain treaties, certain records, and you may want to hold them in your trust or attach them to the res of your trust in some form or another. What you realize is we deal with personal status correction first. And I have for black people here because that's the category that I once fell into, and there's a level of personal status correction that needs to happen. But also here you could put your affidavits, affidavit of life, or all these other different things that people feel they want to do, these affidavits and declaration, identifying themselves as a living man, or however you want to do. Me personally, I don't do any of that at this time. I try to do everything in precedence of priority of what I think is important, and I just haven't got, and nor will I ever. I don't know if I ever will find it important to do those things. But here, actually, as I get down into the trust between personal status correction, which is most importantly getting a court order for myself, so that I can have something that I can put, when I'm going after my travel card, passport, state ID, or whatever. I want the L or B to be on any identifying document that I have, because that puts you in the proper status as far as your nationality, and it brings into effect treaties, the Treaty of Peace and Friendship, Tax Convention, and whatever other relationships or whatever other treaty or international relationships exist between the United States and Morocco. And this is my understanding. And yeah, so we'll leave it at that. It's not to create an argument, because I know some people, when I just said that, probably are thinking like, well, Morocco's over there in Africa, so how are you saying, all of the tax conventions, bilateral investment treaties, all of these different agreements that the United States has with Morocco, from what I've seen, they're very beneficial to Moroccans. And we, as Moors, are descendants of Moroccans born in America, so the same thing applies, including the Treaty of Peace and Friendship and everything that has transpired since it. So that's why, personal status correction and correcting your name is important. And then operating in trust to delineate the estate from the trust, to create that separation from the person or the individual corporation, the straw, as opposed to the general executor that's operating the trust or the estate. So this is why step one, we dealt with personal status correction, nationality, and all of those different things. Who you are as opposed to a United States citizen. And then in two, we constructed the trust to manage the estate, which is what's supposed to happen anyway, right? And in this trust, we may include some of the evidence delineating the actual general executor and trustee for the trust that's holding the estate. And then we talked about a little bit, trust registration statements, which is very important, because that's how you identify that trust in record or in commerce, or records that pertain to commerce, how you identify it specifically. And we did all of that so that when we got down to recording a will, if you decide to do that, then your will can pour over, or your will can move any assets that remain outside of your trust into your trust when you pass form. So, of course, since your trust is revocable right now, if you pass form, as long as your trust is still operating, it'll become irrevocable, because you no longer can. All it can do is perpetuate based off of being administered by a trustee. So I say all that to say, in the beginning, and I'm talking to myself too, in the beginning, a lot of people are more focused on personal status correction, so they're in a rush to set up a trust. But this revocable trust, you definitely want to pay attention to who your successor trustee is and who the next successor trustee, and maybe you want to communicate with this person what your plans and what your intentions are, and you really want to spell that out in your revocable trust, because the way that I understand it is this revocable trust is going to give you access to your estate, to all these accounts and everything, but you're still going to have some of that after you pass form. So don't just think about now, think about after the fact. And it's very important, because if there's, say you have people in your family that don't understand none of this and they're not focused on this, but at some point they're probably going to benefit from it. You don't want them to mess up or prejudice what you've been building. So it is, real important who your trustee is, who your successor trustee, and the instructions that you leave, just in case you pass form. That's just the way that I look at it. Oh, and Also, what I was going to say, not just the instructions, but your trust registration statement. You want to understand that, because if, now we have to jump back down here to the will. If, say for example, you pass form and for whatever reason your will doesn't surface, or say it does surface, but you have heirs or beneficiaries that want to argue about what you put in your will. Well, so I'm just saying, consider that and think about that. The only way that I'm doing my will, at least for the purposes of personal status correction, is I'm doing the pour over will, which basically leaves only one beneficiary for the will, and that beneficiary is what was once the revocable trust. Now it's irrevocable if I pass form, but it's the same trust. And this is why we had the trust set up before the will, because the trust has a certain registration statement. The trust registration statement doesn't tell whether the trust is revocable or irrevocable, because whether a revocable trust turns to an irrevocable trust, the registration statement doesn't change. The registration statement is going to help continuously identify that same trust. So I'm saying all that to say that if your trust is already set up, when you're setting up your last will and testament to pour any estate over into the trust, you can identify that trust by the trust registration statement, which will match up to the UCC. It'll match up to your county filings and whatever other filings you've done to give evidence of that trust. So again, I emphasize how important it is when you consider who your successor trustees are. Because if you pass form, the trust is set up to administer the estate, your real property, and whatever securities you may have redeemed, right? You want somebody that's going to know how to handle that. Maybe somebody that's on your level or somebody that you've taught or studied with. But another point I was going to make. The point that I was going to make is that in your last will and testament, there's an executor appointed for the estate. In my last will and testament, the executor is the man, or the executor is the closest thing, the living man that's facilitating the business for the estate. So that for me as a Moorish American, there's a delineation, right? That title has El or Bey, and it's the executor for the individual corporation or the estate or the straw man or whatever you have it. So I also have a successor executor, right? So that when I pass form, the estate, as evidenced by the last will and testament, can be administered by this successor executor. But the only provision in the will is to turn all of the remaining assets over into the trust. So that there's no conflict of interest, I make sure that my successor executor is also the successor trustee, or maybe even a co-trustee for the revocable trust. So I hope that makes sense. Now, taking it back down to the will, and a lot of this stuff was already covered in other videos, so I'm just pointing out some important things. So let's say we've set up the trust now. Now, when you're taking it to the will, I'm just going to share with you something I've learned in my experience. Doesn't mean you have to go one way or another. Don't rack your brains over trying to do something that's just maybe too complex for you to do. As I stated in other videos, a lot of people will be met with resistance. They'll have a difficult time getting their will recorded properly in their county. Here in Los Angeles County, when it's done correctly, the county will give you an actual SKR, which is a safekeeping receipt. And they give you the real SKR, and they stamp a copy of your will, and you can put that away or file it away or do whatever with it. Now, I say that because in commerce, when we're dealing with trusts, entitling assets into the trust, SKRs may have values. So I just say, so I don't know what to do with the SKR just yet. I have one. And if you get your will recorded in the county, pay close attention to the receipt and read what's on the receipt. That's probably what's going to tell you if it's an SKR. They're not going to, tell you that. Now, if you're just unable to have any success getting it done in the county, then you can always look up the international will. and the international will at least get you done. You might not get an SKR or nothing like that, but at least you'll know for the record that you have a will that sets out the matters the way that you want them to set out. Now, last thing I want to say on this is you could do your will, you could set your estate up any type of way, as long as it makes sense. But you know you need a estate to manage, you know you need a trust to manage the estate. Now, if you start adding stuff to your will, then it's not going to function like a pour over will, because you have to look at it as if the goal of the system is to bring your trust or to bring your estate into probate so everybody can still continue to make something off of it. Your goal is to keep it out of probate and direct affairs the way you want them to. So when you add more than one provision, which is just turn all the estate over to the trust, you add more than that, then you're adding potentially other interested parties in areas for controversy, which could cause everything to be drug into some type of probate court. Maybe that's the way you want it. But so I just wanted to kind of throw that out there. Now let me see. So where I'm at right now with this, so that was a kind of good summary just to make sure you understand different things. Let me go through here. I don't know if I ever really made a video to talk about this. Let me see here. This is important. Authentication first versus, authenticated records have the full faith and credit clause. An apostille does not. So that tells me I want to get most of my documents authenticated if necessary. Anyway, that's not what I really wanted to talk about. Titling assets into a trust. I'm going to just talk about this briefly because it's important. From my understanding, if you want to title an asset in a trust, you do two simple things most of the time, and maybe sometimes more than two. But the basics are you do some type of assignment instrument that will typically get recorded in the county. Maybe you will be able to record it in the county, maybe you won't. It depends, because a lot of counties are dishonorable, but you should be able to record an affidavit of title over personal or real property in the county. So that may be how you would title an asset in a trust. You start with some type of county recording, whether it's an assignment instrument or an affidavit, and then you put a UCC1. But if you're already a secured party and you have a UCC1 where the trust is covering your estate, then you would do a UCC3, which what you're doing is a UCC3 is for addendums, which is adding additional property to your collateral. So to title an asset, you're basically putting an affidavit on it in the county or some type of assignment record, and then you're filing a UCC3 on it to make it part of the collateral or the assets of your trust, simply. You might do this for tangible property, intangible property accounts. This is something that the executor for the estate is necessarily doing. It's really the executor and the trust. Remember, the executor and the trustee are one and the same, right? So they're finding, claiming, and transferring assets into the estate. So in addition to so let's look at this real quick. Hold on, let me see something. Titling assets into the state. I got a PDF here. What is this here? This is my real UCC financing statement. This is mine. So, no, this is not mine. This is just an example of titling an asset into a state. But this is a UCC3 that connects to my master filing, which you can see. This is my filing number right here, my initial financing statement. Most states that you do UCCs in, they're very good about tracking UCCs. Ohio is excellent, by the way. So what I'm showing you here, this is a lien for $100 million per se, right? And it's on an asset, security asset, SN, whatever. So this was like on my social security card or something. Because that card is an asset, I'm operating through the trust. Let's see if we can see it here. See, who's the secured party? Name of the party authorizing this amendment. So this is a UCC3. And I didn't have to write this in here. If you've already done a UCC1 financing statement, you're going to be able to select this as an option, or it's going to be the only option that you can select. And who is the secured party? Moore, Ill, Sylvester, Dealand, trustee, under declaration of trust, dated, etc. This is the trust registration statement that I was talking about. And from here, it's important, if you haven't done so, that you read Treasury publication FS0049. Google it if you can't find it, but it's also in the master file. I'll go back and I'll point it to you because it explains to you these trust registration statements. This particular one, when you use UDT, under declaration of trust, demonstrates to the Treasury and everyone in commerce that this is a revocable trust, which the IRS, from my understanding, treats it like what they call a grantor trust. Now, while I'm thinking about it, let me say this too, it's very important. Some people set up, got their foreign tax ID numbers, and they did it without connecting it to their social. Because when this information came out, it was at a time when everybody was running from the usage of their social, and still some people are. I think that the social is an insurance policy for the individual corporation, which is kind of the surety in commerce. And a lot of people have ran from it because they've been abused by it through those who had the knowledge of how to use it. So I really believe that the individual corporation should be made one of the beneficiaries of the revocable trust, and that you don't get rid of it. And it has its social security number, which is the insurance number. But the number that you effectively operate from is through your foreign tax ID number. The IRS, if you set it up correctly in the beginning, I believe they will treat it as a grantor trust. It's still important that you establish who the grantor trustee and the beneficiary is, but if they're going to treat it as a revocable trust. And from their perspective, for those who are going to do returns, because this will become important later, not really in this video, you're only required, the IRS is treating the foreign tax ID number and the social security number as, one and the same, meaning that you don't have to do multiple returns. You could do just one return. So take that with a grain of salt. Don't think it means that it prejudices anything that you have. You just have to know how to operate. And this is what I'm trying to share with you. This is how the master file is built. It's built on this basis, right? So this secured party that you see right here, Moore Ill, trustee under declaration of trust dated 5/30/79. This secured party is a trust. Its tax ID number is what? My foreign tax ID number. That's the trust that's managing the estate. But all this is what I was showing you, and I didn't attach the document, but this is just a lien for $100,000 on an asset, right? So let me go back here though. I want to show you something. We'll go look at my secured party filing real quick. But first, remember I was talking about the trust registration statements. As I mentioned in so many other videos, you can read about that right here. And I said earlier in this video why it becomes so important. Now, when it comes to, do you need a foreign tax ID number? I don't think so. But, I'm just talking in general for everyone. I don't necessarily think it's necessary. But for me as a Moorish American, because history as pertains to me, I feel I do need a foreign tax ID number. But everything that I've discussed to this point and everything that we've done to this point, it didn't matter. We could have just had a tax ID number for a trust, right? So I'm just saying, do things the way that they make sense to you, but they have to make sense. And you have to have some basis for why you're setting it up that way. Okay? Now, let me share this story with you real quick. Last week, I called the IRS because I wanted to get some information about my foreign tax ID number. So the first thing I'll share with you is you got to call the international business line. Never call a domestic United States tax number asking questions about your foreign tax ID number. It's going to be an unpleasant experience. I'll just put it that way. And if you don't believe me, just do it. You can see it's going to be an unpleasant experience. So, but I called the foreign international number and I asked them about my trust, and I gave them the tax ID number. And I asked the lady, I said, I would like to know, how is this, how is this from the IRS's perspective, is this considered a foreign grantor trust? Or excuse me, is it considered a grantor trust? And she said, well, it depends on the documents and what you gave them when you set it up. And I said, okay, well, I said, that's probably been since 2013 or 2012 when I set this up. And quite honestly, I probably didn't do everything the way that it should have been. So how can I know what the classification is? And she said, that's nothing that I would be able to see. Then I said, well, how would I correct the information if it's wrong? She said, well, you'll have to send in your trust instruments or your articles or your documents, and they will make the corrections based off of what's in your documents, basically. So I said, oh, okay. Well, can I fax these? She says, no. At this office, it's, at that office per se, it's only ink signatures and documents and etc. So then I said, okay, well, can you give me the address? And then she gave me the address, and that was cool. So I said that to say, it kind of reminded me. This is not the first time I've heard the information, but it is the first time I think that I got that information directly from somebody in the IRS. And it just reminded me that our trusts, we have to be giving them notice of our trusts. And another very important topic that I will say is, she said they have to be signatures. When they say they have to be signatures, that means they want originals or certified true copies, only certified copies, or originals. So I'm going to go back to that point. But it reminded me that, especially when you're dealing with a revocable trust, you can change things as necessary. You can provide a certification of trust, a memorandum of trust. You can give them your original trust instrument, right? So, but it's interesting because I thought, with all the things I've tried to do and all the different things as far as dealing with this information, would any results have been different if I gave the IRS a complete full copy of my trust, or at least a memorandum of trust giving them all the specific key important points? If I gave them an original, would anything be different? This woman told me that they need originals, basically, when she said it needs to be ink signatures. So I said I need to get on the ball because it's something that I was going to do a long time ago and I forgot. Like many of us out there, we have these tax ID numbers, but we never gave the IRS, which I could also say the Treasury, because it is the Treasury. When you're dealing with the IRS, you're dealing with the Treasury. Sending the IRS something is sending it to the Treasury. So I thought about that. I said, man, giving them the trust indenture. And then you know what I did? What I did was I took my revocable trust. Now, what is my revocable trust? Because we talked about the trust registration statement, and if you've been going through the master file, you've seen there's a few different types of trust. Remember, it's a revocable trust, so it doesn't necessarily have to have a trust indenture. But if you open up a bank account, I doubt you'll be able to open up a bank account for a revocable trust without a trust indenture. So you want to create some type of indenture or at least a memorandum of trust. And at the same time, remember it's revocable, so it can always change. So here we had just one example of what could be used, which is a declaration of trust when the trustee was itself. Here it is. And you can build from here. This was just a basic template. It's already longer than I would really want one to be because it's a revocable trust. I don't need 5 pages. I really want it down to 1 or 2 pages. But you can have this. You know, some people wanted to file a trust behind their UCC. So you read through it and you see if that works for you. What you could also have done, or what you can do, instead of doing the declaration of trust, you could just use trust minutes. These are the trust minutes. Trustee called the meeting to order and affirmed that officially July 1st, 1961, the trust was created but left properly unmanaged until whatever date of 2000 whatever, until accepted by appointment of John Alex of the family Doe has been accepted as first trustee of the trust. So this is just expressing the trust. These minutes are sufficient to be your declaration of trust, right? Now, in addition to that, I'm going somewhere with this, follow me. So let's see. So we just looked at the trust, a declaration of trust. Then we looked at just using minutes. Then here's this trust agreement, but we're going to leave that alone. What I wanted to find was a memorandum of trust. I'm going to change this trust agreement to memorandum of trust because that's what we really need to put here. Do I have it down here already? Here's a memorandum of trust. So remember, what I'm trying to show you is you may want to send evidence of your revocable trust, however you're operating it. You may want to send it to the Treasury. And you may want to send the original. You may not. You think about it. And I'm going to tell you, so I like this one right here. It's very short. Memorandum of trust. We got the article, the name and the address of the trustee, the date of the execution of the trust, the property of the trust. Right here is where I would put either a Schedule A, I would reference my birth certificate. Remember, if this is a fresh memorandum that you're going to send to the Treasury, I would direct them to where the property of the trust is so they can see the trust schedule. And basically what that would be is the UCC filing for the estate trust. That's what I was getting at. You really want to link your revocable trust to the UCC filing. As I was saying before, when I showed you my secured party was a trust, I told you that's my foreign tax ID number. So essentially what I'm doing is I'm giving, I want that foreign tax ID number to link up to my revocable trust, and I want all the property of my trust to be linked back to the UCC. I want those one and the same, basically, for good reason. Now, successor trustee, remember we talked about that? Okay, that's a very 3-page trust indenture. Now what I did, now let me show you one more thing. Let me show you my UCC filing. So we're going to scroll down here, UCC filing and county recording. And this is the last thing we're going to kind of talk about in this video, but we're not even on that subject yet. First we have to go look at, where's it at? My UCC recording. I think this is it. This is my UCC filing, I believe. It is. This is my UCC filing, my main one. This is just the first page of it. So let me show you something here. Once again, this is just the filer at the top. The organization name. Notice I didn't do an individual name. This is the debtor. This is the debtor organization. The Sylvester Dealin Moore individual corporation. The John Alex Doe. Right? Who is the secured party? This is my initial financing statement. And you see I have the declaration of trust statement with the date. That's the secured party with the foreign tax ID number, becoming the secured party for the estate. Now let's look at the collateral information. These are all of the items these are some of the property that was secured in this initial financing statement. I had memorandum of trust. We just kind of looked at a little short version of a memorandum of trust. I have an affidavit of title attached to the certificate of live birth with the full faith and credit. And then there were some QSIP search results that was attached to. Then I had a copyright that was published in the newspaper, and it was a real nice one because they put the seal on it. Then I had the authentication from the state of Ohio, my Moorish American nationality and name proclamation documents, and so the most significant thing, though, I would say, was the memorandum of trust that was over the affidavit of title attached to the authenticated record, because that's the estate that's being secured by this non-UCC filing. So it's an entitlement. Now, what I did, remember I told you I had the conversation with the lady from the IRS, and she said, so what it inspired me to do is I said, well, let me send the IRS my trust. And you know what I did? I sent them the original of everything. So I sent them the original certificate with the full faith and credit, all of that. I sent them the original copyright that was published in the newspaper with all the seals, everything. Original nationality, every document that I sent them was the original, and I sent them the UCC financing statement and the original behind it. That was what I was giving them as the evidence of the trust. Now that's significant because this is just the initial filing. There's UCC3s in there that delineate my Moorish American nationalities. There's references to Resolution 75, the Treaty of Peace and Friendship. So at this point, that's, all of those notices are indirectly also being given by me giving them my original trust and all the original instruments. And I talked to one of my colleagues about that. He's like, why'd you give them the originals? Why didn't you give them copies? Now, here's one thing I've been saying for the last year when it comes to doing things in commerce, especially if you're discharging debts or just dealing with the Treasury in general. I never think that you will have success using copies of instruments unless they're certified true copies. So I realized it's like, I'm not getting the full faith and credit on this birth record. I'm not authenticating these copyrights just so I can put them on the shelf and say, ooh, look at these. And I really don't trust bringing those instruments in court. It's not really necessary for me to bring those instruments in court when I have them recorded behind the UCC. I can bring the UCC into court. So I figured I have to use these instruments in commerce. I have to use them somewhere. I'm getting them for some reason. So I decided to send all the originals, because also, as I always say, if you go to the bank, you go to the post office, you can never use a copy of a check, a copy of a money order, a copy of any type of document in commerce. It always must be original. I think this is a simple point that a lot of people miss because they don't want to give up their originals just for whatever reason. And I think that a lot of times the paper has no value unless it's an original. So it's just something to think about. So I don't know how it's going to turn out, but I did. I sent them all the originals. Now let's look at one other important thing. That important thing is, let's see. Let's go back under the will and testament here. I put this down here because once you have your trust and everything set up and you get your will recorded, then you want to check out IRS Form 8855. This is a new one for me, but you're going to see it goes right into alignment. I'm going to pull it up here. Now, don't do this without reading and doing your own research, because I haven't done the thorough research on it yet, to be honest with you. But off of bird's eye view, off of first sight, it seems to meet a lot of the requisites of exactly what we're trying to do. You must always read the instructions of these forms. The name of this form is Election to Treat a Qualified Revocable Trust as Part of an Estate. Now, I don't know if I got all the way into this earlier, but I was saying when some people started out, they were trying to get their foreign tax ID number without connecting it to the social. I believe in order to navigate and so that you can title the estate properly. Remember, you're trying to claim securities that were attached to your social security number when you get to the redemption side of things. So this is another very important reason of why you want the social connected to your revocable trust or your foreign tax ID number that's controlling the estate. You need them connected. So if you didn't set them up connected, because if you look at our SS4 form and the instructions under the master file, which is up there, we let's see, where's that? Foreign tax ID number. These instructions, we set it up the right way from the beginning. But if you didn't and you still had that foreign tax ID number, there's no reason to start all over. The way that I see it is you can use this form and correct all of that. This is an election to treat a qualified revocable trust as part of the estate. Remember, you always need a trust to manage the estate. This is why they create constructive trusts on top of your so-called individual corporation estate. So we're electing to treat our foreign situs trust as part of the estate. And if you don't completely understand why, you don't have to do it this way. You can do it another way. But I can't explain the fullness of why in this video. You see how long this video is, and the reasons why get more into when you're redeeming securities and discharging debts, and that's not really the subject matter of this video, so I can't go into that. But what we can see here is the first box says name of the estate or filing trust if applicable. It might, or obviously that'll just be John Alex Doe. For me, I'll put that in all capital letters. Employer identification number. I'm going to put the foreign tax ID number. Name of the executor. I'm going to write the name of the foreign executor as delineated from the name of the estate. So it's probably going to have my title, my L or B. But notice if you read closely here, it says name of executor or the filing trustee if applicable. Didn't I tell you that the executor for your estate is also the trustee for the revocable trust? So then they say the type of entity prior to election. You could use a domestic estate, a domestic estate, or a foreign estate, or a domestic trust, or a foreign trust. I always I go with foreign trust. This is a foreign trust because I put my 98 series tax ID number there. I'm treating this as part of the estate, right? So you can read the declarations there. Then it says signature of the executor or the filing trustee in parentheses. The name of decedent. Again, I have the all capital letters. Then the social security number of the decedent. That's how you're merging them. Then I put the social security number there, right? And so that's an interesting form that you may want to consider. Now, I don't know what would be a good task for you is to call the IRS. Well, first find out where this form goes. Maybe the instructions are up here. Do they have a number? Well, you can call the IRS and ask them about this. Maybe you can also send your revocable trust here, right? Maybe you can. I don't know. Now, there's one last thing I want to talk about, and then I'm going to close this pretty long video out. I hope this video is informative. So again, as I said in the beginning of this video, this is going to come somewhere around video 5. And this is where I'm still at, which is the county recording, because it's really about merging the estate and the trust, right? Now, let me go back to something real quick. I mentioned this kind of earlier, but we looked at titling assets in the trust. Here we did, titling assets in the trust. Hypothetically or ideally, although this wouldn't be the case, look, here we have it. This is a notice of lien. Assignment of interest in a financial asset. This would be the recording that I want in the county. I said hypothetically because they're probably not going to let you record something like this in the county. But this was the lien that I was putting on that car because the trust holds the estate. So I'm going to put a lien on it. I would want this first recorded in the county. And then when you seen that UCC 3 that we looked at earlier, this is the actual document that's imaged behind the UCC 3. Here's something. Check this out, the definition of expectancy. The possibility of a future enjoyment of something one counts on receiving. So basically that's an asset. Expectancy is an asset. So it's the nature of why we file these liens. Look, assignment of estate in favor of the creditor. So you could use all of these different things. Assignment of the estate in favor of the creditor. The creditor is what? The trust. You see it again under declaration of trust. So these are examples of what I would say is your county recording. That's some type of lien, assignment, or deed record that gets recorded in the county, and then you put the UCC 3 on top of that. All right. So again, when the IRS said send originals for your trust, I sent them my UCC filing that has a memorandum of trust behind it. There was something else that I sent them too. So look out for it because I didn't talk about it. I'm gonna load that in the master file. I'm gonna put that somewhere in here. You will see where I put in here. You know, I'm gonna make it important that at some point you send your trust instrument to the IRS. Now what I did is I actually created a one-page memorandum of trust because I was thinking if I have to send this to the IRS, there's some very specific things that I want to tell them. You know, or that very specific instructions about the trust. So I created an additional one-page memorandum of trust, you know, even a little bit different from what's in the irrevocable trust. So let me get on to the last part so I can close this out. I'm glad we got through all of this. So UCC filing and county recording. This is something that I think is very important. It especially applies for people in Ohio. If you were born in Ohio, if you live in Ohio, or if you have a state in Ohio. Ohio just seems administratively one of the best places with the tools to administer your estate. And I'm referring to UCC filings and managing the UCC filing system for your estate. It's just one of the good places. So, and that's because of the technology behind their UCC filing system. And there's other good places too, you know what I'm saying? So, but this is what I found in Ohio. And the thing is, I'm a native of Ohio, but even if I wasn't, and I didn't like how my state dealt with UCC filings in the states, if everything was difficult in my state to get a trust recorded in a probate court, I would if my state wasn't an option. For example, like I hear people in Michigan, they have a very tough time, or in Michigan, they have a difficult time with a lot of this type of stuff. There's a few other states too. Ohio may be a good alternative. But anyways, what I want to direct you to is Ohio County and Probate Courting, Ohio Revised Code, I want to say it's 5817. Let's go look at it. Here it is. It is determination of the validity of a trust or a will during the lifetime. So I'm going to just go right on down to 581702. Action by a testator. A testator is the person who is making the will. A testator may file a complaint with the probate court to determine before the testator's death the testator's will is a valid will subject only subsequent to revocation or modification of the will. The right to file a complaint for determination of the validity of a testator's will under this chapter or to voluntarily dismiss a complaint once filed is personal to the testator and may not be exercised by the testator's guardian or an agent under the testator's power of attorney. A testator who desires to obtain a validity determination as to the testator's will shall file a complaint to determine the validity of both the will and any related trust. This shows you that you can get a court order about the validity of your revocable trust controlling the estate. This may be something that you want to do before sending the trust to the IRS, or maybe you want to do it after. This is just something powerful that I think you should do if you can. And you also always want to go look in your state and check out what the probate code or how the probate procedures are in your state. You might find something similar but not exact. So before you do this, of course, you want to familiarize yourself with trusts, the parties to them, wills also, grantors, trustees, beneficiaries. Now let's look at 581703, action by a settler. The first one up here said action by a testator, right? That's the person who makes the will. A settlor is the person who makes the trust. It's the grantor. A settlor may file a complaint with the probate court to determine before the settlor's death that the settlor's trust is valid and enforceable under its terms, subject only to subsequent revocation or modification of the trust. The right to file a complaint for determination of the validity of the settlor's trust under this chapter, or to voluntarily dismiss a complaint once filed, is personal to the settlor and may not be exercised by the settlor's guardian or an agent under the settlor's power of attorney. A settlor who desires to obtain the validity determination as to the settlor's trust shall file a complaint to determine the validity of both the trust and the related will. And then you can read the rest of that. So now you can see these different methods, the Form 8855 with the IRS, the procedures set forth in the probate court to connect and to validate the trust and the related will, or the will and related trust.